We're back, and I think my hair looks better.
Yeah.
So I learned just very recently that apparently not all conditioner is leave-in conditioner. I learned that this morning, and I just assumed by definition if you left conditioner in your hair, it is leave-in conditioner. And I guess. So apparently I'm going to go buy leave-in conditioner or product to try to keep myself looking from, because I'm kind of Bob Rossing it, and if I make it, I'm trying. And now with the screen and everything, it's a bit more. So, all right, we're back and we're going to be talking this time about a whole bunch of different questions from a bunch of noobers. So the first question is, can boards sign proposals without having a notice to board meeting to discuss it first?
I think as a general rule, you don't want to sign proposals, especially when they are a large proposal, without having a board meeting to approve the proposal first. That's your general rule. Then if you've got, now that it depends starts coming in, because if the board has previously provided the authority for some person, the manager or the president to sign, then the answer would be yes. But the general rule would be, you can't move forward with a board action without first having a board meeting to get it approved. Now, if there's an emergency and something goes boom and you got to fix it, then you have to fix it.
Well, I think what we see happen in operations, or as I like to call it, reality. So what we see happen in reality is, you mentioned like an emergency or something, we're going to do a sidewalk project. So we do a sidewalk project every year at an association we work on together. I'm trying not to use association names. Ian, if we did, make sure you deleted those out for us. So there's an association we work on together. Every year they do sidewalk projects, and it can be kind of expensive. Those sidewalk projects sometimes meld into curb gutter projects. And all of a sudden, our sidewalk, which we said, okay, no problem, we're gonna do the sidewalks, now we're doing curb gutters, and it's concrete, and we've already lifted it up. So, we talk to the person who's in charge of infrastructure. Infrastructure chair's like, yep, go ahead, we're gonna approve it at the next board meeting. So we will end up approving a contract, but really we're not approving it till the next board meeting.
Right.
I think that's probably our most common violation of that contract rule. Something like that.
And it happens quite a lot. What I would say to whomever is signing it, whoever is signing the proposal, is it's not technically with the power of the association as approved by the board until it gets approved or ratified at that next board meeting. So if it's a contract or a proposal for $1,000, even $2,000, $3,000, $5,000, maybe it's not a big deal. But if we're signing a proposal without board approval and it's $15,000, $20,000, $50,000, $100,000, that's where I start to say, have some caution here, because what's required is a 48-hour notice meeting, and it's 48 hours. Is there a way that we can wait 48 hours so that you're not signing something that the rest of the board members might say, no, we didn't want to contract with this contractor for it? One thing I see a lot as well is, do we still need to have a board meeting to approve a proposal or contract, even though we've already budgeted for this? And the answer is yes. The answer is yes, because just because you budgeted for an expense doesn't mean you budgeted for that expense to be paid to this certain contractor.
We're passed a resolution that says if there's a pre-budgeted expense, that whether it's the infrastructure chair or whatever on the board can award those contracts.
That's exactly right. That's where the it depends situation come in, because if the board has delegated its authority to enter into a contract to somebody else, to either the manager, the infrastructure chair, the president, or the vice president, another officer, then you already have the power of the board to do this because the delegation has already occurred. But absent that, I would be careful, especially when we're talking about big ticket items.
Right, and just also as a reminder, because this is a question that we have, boards cannot pass, you can't vote over email.
Please don't, because there's never any votes over email. You can have a lot of discussion. It's just an informal poll at that.
Yeah, I'm in favor of doing this, that kind of thing. There's no votes over email.
No.
Do board member emails count as association record?
Yes, 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 and yes. It depends. It depends on who is copied on these emails. For our purposes, we're working with Newell Property Management, which means the folks that are seeing this, if they are either board members or your noopers, they are with a management company. And so if you have an official records request and they ask for all communications regarding the landscape contract, including emails. The question is going to be, who is the records custodian? And if you have a management company, the management company is the records custodian. And so if I ask for board member emails, the question is going to be, is the manager copied on those board member emails? Because if the answer is yes, then those emails are free to be given out to someone. Unless, of course, there's an exception. There's always an exception to the rule, which means if it is attorney-client privileged, then you would be able to keep it from being divulged to the owner. Otherwise, if it's just board members emailing each other, it's not an official record. It's because no board member is obligated to do business by email. And we don't know, number one, if that email even exists, or if the board member received it. Did it go to spam? Did it get deleted by accident? We have no idea. And so now, if we have a records custodian, they are the central point of contact. They're the ones that would be responding to the request for email records.
Yeah, and I think that one of the things we try to have at Newell, which I think works well, is having a central point of contact on the board when we send something to them, and then we're getting directed responses. We've had situations in the past where we've sent something to a board member, and there'll be a group of board members on the chain, and it's kind of like a text message. Everybody starts using the email for all sorts of different purposes. It becomes the one email. And we'll end up with, let's say we were asking a question about an ARC approval. Do we agree with approving this ARC to install new storm windows? No problem. They all say yep. And then somebody says, hey, Marty, you want to go to the bar tonight? No, we're going to, and then this email. And this is all part of this email chain. And then this email chain becomes really long. And then later on, we're asking a bunch of questions. And then someone makes a records request. And we've got this email chain about Marty and them going to the bar and all of this kind of stuff. And you're like, oh, goodness, this is not. So having single emails, a single point of contacts, makes it easier. The other part of it is that at Newell, we use, not E-Verify, that's our system for I-9. So what is the electronic disclosure? It's something for when we get like subpoenas. E-Discovery. I got there.
It's great.
Do you know what e-discovery is?
Yes, I do.
All right, so of course. So we have e-discovery. So when we need to pull something, we'll actually have e-discovery pull that for us. And it's going to pull absolutely everything. And now we end up paying someone like Kyla to go through 4,000 emails.
To make sure that we're not sending attorney-client privileged information. We're not sending any information that should not be given to the owner.
And we have a situation with that right now. It involves a slip and fall, and it's actually it was a subpoenaed request for a slip and fall thing, but everything has to go through them. And there's literally 4,500 emails just because there were so many emails floating around with this one master association. They're going to have a six-figure legal bill to review these emails, and that's something we try to avoid.
Email is the preferred form of communication these days, but maybe some board members don't realize that those emails are discoverable in a subpoena that's later down the road, but they also could be discoverable by the unit owners. And you might not have anything to hide. It's just the sheer extent of the emails that you may have. Those have to be given.
Correct.
If it's requested. So
when can an emergency board meeting be called? I know one answer to this.
What is the answer?
Well, when emergency powers are granted.
That's right.
So if we have a state of emergency and there's emergency powers, if there's emergency in the name 2 or 3 times, we can call emergency board meeting.
That's absolutely right. So when there is a state of emergency that has been issued by the government, then yes, you can call an emergency board meeting. So what is an emergency board meeting? It is a board meeting wherein you are not required to provide the required notice requirements. So there's no notice, there's no agenda. We're going to get together because something crazy has happened. And it's a hurricane usually.
Let's be honest.
Sometimes it can be a fire. Sometimes it can be a flood.
Oh, yeah. You're talking about individual to the association.
Exactly.
So if an association had a fire.
Yeah. So it's not just about the hurricane, but certainly if it's an emergency to the association. Now, take that with a grain of salt, because an emergency to the association doesn't mean one of my board members is going on a cruise tomorrow and can't make it. Okay, darn it. So it has to be a real emergency. And at that point, then you can meet and make decisions that you must make, including borrowing money, including assessing special assessments. But those emergency powers only extend to the extent that there is still an emergency occurring. So you know, if it's been a year after the hurricane and most things are going back to business and back to normal, I don't think that you can still use the fact that we got affected by a hurricane a year ago, which means we're going to still use our emergency powers. And I want to make that clear because I just had to deal with that a couple days ago, where I had to go back to a board to say, you cannot keep using your Hurricane Ian emergency powers when that was about, what, 3 years ago at this point?
Yeah, we're using Milton now.
Yeah, that's right.
Yeah, we have a similar situation here with an association that I'm involved with. And what happened is their documents say that they have to hold their annual meeting in November.
Yeah, nobody's here.
Nobody's here. So when the hurricane hit, they said, well, you know what? Under the emergency powers, let's hold it when everybody's here, because this is an association on Gulf Shore Boulevard. They had millions of dollars in damage. Let's hold our annual meeting then, which they did. But they really like holding that annual meeting in February, right? Because everybody's here. So they keep trying to hold it in February, and I'm like, guys, you know, we can't. You can only do that so often. We need to just rewrite the documents.
Let's
just rewrite the documents, and we can do that at the next annual meeting, which is going to be in November. So unless we get a hurricane, knock on wood, that does not happen. So that's when we have emergency meetings. Who will enforce term limits?
Who will enforce term?
So I'll be honest, I don't want it to be us. That's all I know is that, like, as the management company, you know, there's the big questions that we're being asked are, I'm working on grammar today. Big questions we have are, who's going to enforce a term limit on a director? And I have a situation with one of those recently, and it was in one of your classes, and you gave an idea, which we're going to try, which we have tried, which is, so this director resigned from the board and was appointed back on the board about 2 weeks later.
These are the condo term limits.
Condo term limits. So in theory, he's not been on the board he now will have been on the board. He was on the board for 6 years. He's now been off. He's been put back on the board. I don't know if that's a new term or not.
Right.
And then the next part of that is, you know, who enforces that? Who says you've been on the board for 8 years? You can't do this anymore.
Great question. Since this is a condo association, I would assume that the DBPR would have jurisdiction over this. I think the first set of parties that would say, no, you've been on the board for 8 consecutive years, you can no longer run. Actually, you can run.
As long as you're unopposed, you're
right.
Okay.
You're either unopposed, or I think you have to get 2/3 of all the folks that voted. They have to vote for you. So even if you win, because you get more than a majority, if it doesn't hit 2/3, you still can't serve on the board. And I think that comes into play if there is somebody else who would have won or who would have taken the seat. And if you refuse to give it up, that person would file a complaint with the Department of Business and Professional Regulations, and then the process will go from there.
Yeah, because it kind of feels, not to make this too dramatic, but it almost feels like a coup thing. Because let's say you've got a president and they run against somebody else. They don't win by 2/3. And we're really in a position now, this could actually start happening because the clock is ticked out, right? So this is new. The president wins. He's the point of contact. He's saying that I should be on the board. The management company's like, well, this is the law. As managers, we have there's some freedom in the fact that we can't practice law. I can't tell you how that law can be applied to this situation.
Right.
Really, only a lawyer could do that.
Mm-hmm.
So it seems like there's this split thing between the DBPR, who's going to take months to investigate this, and so who's actually in power, between a lawyer who the management company has to get approval from the board to talk to the lawyer to give an opinion. I don't know how we're going to handle it if it ever happens.
Right. And for my part, if I provide an opinion, that's what it is. That's all it is an opinion and a recommendation on how to proceed. If the board decides that they're not going to proceed on that, then the board can take a separate action.
Would the board be the one that's getting to make the decision at this point?
Likely, yes. I would anticipate that the person that would have taken the seat had this other person who doesn't want to give up the seat. That person would file a complaint with the DBPR. In the meantime, I think the board member that was previously in that seat before the election would stay on until the DBPR gives us a decision on which person won the election or which person has the ability to serve on the board.
And the problem that's going to exist then is usually when we see something like that happen, there's something going on in the community.
Yeah.
Because in order to get to that point, you're going to have two camps. The camp that the current person is supporting him doing whatever option A is, and the camp that's supporting option B. And the problem now is going to be option A gets totally called into question. So whatever direction the board they move down, let's say that we're installing a new swimming pool or something, all of that's going to be called into question, any decision that was made, because was he actually, So
The answer is yes, by the way. The board member that's in that seat serves, the language is serves until the next annual meeting or until his or her successor is elected or appointed. And so that previous board member can sit in that seat until the DBPR gives us the decision.
Yeah, so that's, I knew that, but I didn't actually think about the application of that to this situation. Because I was thinking about the application of not having an election, but the argument is the election is up in the air. So that's an interesting point. So whoever the seated person was previously would be the person who would have been turned out.
Yeah.
Interesting.
It doesn't look great. It doesn't feel great, but that's going to be legally supported.
Well, hopefully we don't have to go down that path anytime soon. Now, the other area that's going to be coming into question are the board certificates.
Yes.
To take your classes, the directors that are taking their classes. Who is responsible for kicking somebody off the board if they didn't take the class?
Who is responsible?
Again, I don't want it to be me.
I don't think that you would be responsible for doing it. I think if there is an issue,
because we know that
if it's a condo or a co-op, it's under the jurisdiction of the DBPR.
Right, but DBPR is going to open an investigation into the management.
What do you mean?
Well, anytime there's a DBPR complaint, the management company is going to be named in the complaint.
Maybe I haven't seen that as an every time thing.
Well, I wouldn't say every time.
Just against the association.
I mean,
because I don't think that it's right for the management company to be named in this complaint when it's an association issue.
So I have seen now granted this was an HOA, not a condominium, but there was a complaint regarding actions that were taken by the board of directors for this particular HOA. And they named the management company as well. They named both the HOA and the management company. And ironically, they named the prior management company. This was one where Newell had resigned. So they named the company before Newell, they named Newell, and then they named the next company afterwards, because we all saw that this was going to be a mess.
Right.
And this new company actually, I think, had resigned as well. But they named the management companies for executing the board's decisions. So the management company itself did this. So that's what I was thinking about. In this case, I've not ever had a complaint on this. I've never seen a management company that's had a complaint on this, so I don't know anyone I can talk to about it. But
I don't think that it would be, I think that if I was representing the management company and something like this came in, I would try and get the management company dismissed, because I don't think you all have the right or maybe the authority to say, okay, you can't do this now.
Yeah, and also while we're talking about if you were representing the management company, it's important to remember that Kyla can never represent Donnie or anything. And another, I know a person that another management company owner who there's an attorney that they were good friends with, weren't doing any business at the time. They had them do some trust work for them. And then like a year and a half later, that person started doing work for the management company itself, or not the management company, but for the management company's clients, the associations of the management company. And it became a bit of a mess because that disclosure had to exist continually. Just so everybody knows, Kyla will not ever represent Newell, even though we would love to have her. The problem is that, and this is kind of a management company. So there's a lot of positives to management companies and owning a management company, but I'll say one of the negatives is, as you know, Kyla as an attorney, she needs to do business with our clients because Newell there's a lot more legal money in clients than there is in Newell. We don't really have, from a legal perspective, Newell probably has like 3 questions a year. One of them was, do I need to worry about, so we don't have a lot of that. Because of that, it creates conflict, I guess what I'm saying. So I just want to clarify that Kyla doesn't get paid by Newell.
I will say, so back to this question regarding the certificate.
Yes.
The statute says that person's service on the board is suspended for so long as they don't have the certificate, if they've now served 90 days after they were appointed or elected. It doesn't say who makes that call. But I think the question would be, has it been 90 days or has it not? And I don't think it's the management company's job to say, board member, you are suspended. What needs to happen is the board needs to get together. You need to get a legal opinion that says, yes, it's been more than 90 days. It is my opinion that this person is suspended for so long as it takes them to get the certificate. Now, if that board member refuses to be suspended, I think it's it behooves the rest of the board members to say, we have a legal opinion that says it. Let's look at the facts. You were appointed on this date. It has been well over 90 days. The board needs to back it up. They have to be the ones to make this decision.
And then, but also just to clarify on this, because then this is something I don't know. Just being suspended doesn't mean you're removed from the board.
No.
So it doesn't mean you need to hold another meeting and appoint someone else to the board.
No, you're just off the board, suspended from service until such time as it takes you to take this free class. You just need 4 hours of time.
And also, when you say it's free, it's not always free.
It's not always free. It's free when my firm provides.
Yeah, so when Newell does it with Kyla, it is free. If you're going to, there are some other companies that you have to pay. It's not much, $20-25, and it's free through the DBPR. And I want to give you some props. I have gotten a ton of compliments that our class is so much better than the DBPR.
Well, thank you.
Well, but it came kind of as a backhanded thing because they're like, why did you tell us to take the DBPR class? It was so bad. Yours was so much better. I'm like, I'm sorry. It was free.
Yeah.
You can ask for your money back from DBPR. All right. How long? We were talking about certifications. How long is the certification good for?
It depends on whether we're talking about condominiums, homeowners associations, or are we going to talk about co-ops?
We're trying to avoid co-ops today. We will do a separate thing for co-ops.
Yeah.
I think we talked at the beginning of this, and we'll talk about co-ops because I do want to have a conversation with you about the certificates and all of that. We'll do that as a separate 2-hour class for the 25 co-ops that still exist in Collier County.
That's right. Okay, so for condominium associations, the certificate is good for 7 years, and you are required to take a 1 credit hour CLE or continuing education credit each year that you're serving.
So if I took, let's say that someone took I don't remember when we did the classes. February, March? I don't know. Let's just say it was February. So if I took a class in February, when do I need to take my CLE by if I'm a director?
In that year?
So I need to take it before the end of 2025.
Yes.
I can't take it in January of 2026.
No.
Okay.
In
I need
that
to take it in 2025.
that fiscal year, in that year.
Are any CLEs out there yet?
Well, that's what I was going to
Because
say.
I actually, we need to start that. I don't have one.
We do need to start that. We needed that last year when this law was adopted.
Yes.
We need it this year.
But doesn't
now
the
that
DPR
this
have to approve those? Or somebody
Yes.
has to approve them,
So
right?
a different department of the DPPR has to give us the rules and the different confines on what this class needs to be. That's not there yet. So stay tuned.
All right. It depends.
It depends.
Are condos with elevators required by law to reserve for them? I assume they're asking, do you have to reserve for elevators in condominiums?
Yes.
It's going to be over $10,000. So,
Yes.
yeah.
Yes.
Yes.
Even if you don't have the SIRS, if it's a common element, yes.
I'm actually just now realizing some of these questions are actually from directors.
Oh, great.
So,
That's all right.
if a board member becomes delinquent in their dues, must they be removed from office?
Yes, they are more than 90 days delinquent in the payment of any monetary obligation. It's not
And
just
at that
their
point-
assessments.
And also to clarify, they're not suspended.
They are kicked off.
They're
They are
removed
deemed
from the
to
board.
have abandoned their post. So, exactly. No, they're deemed to have abandoned it because you are trying to make decisions for the entire association and you're not paying your share. And so the law basically says you don't want to pay, and it's not just your assessments, it's any monetary obligation,
That makes sense.
then you've just abandoned your post. You've abandoned your
No, that actually makes good sense. I'm impressed that our legislature came up with that. It's better than the after the fine committee hearing, you can still
you can
clean your
still-
roof.
Exactly.
Next question we have, it's just I guess it's about proxy voting. I'm not sure exactly where that question one is.
Well, let's just talk about proxy voting.
First off, what's a proxy?
What is a proxy? It is a document that says we both live in Appleton condominium and I will not be able to be at the members meeting. And so in order for my vote to be cast, I give a donee the right to vote for me. And there are 2 different kinds of proxies. There's a limited proxy and there's a general proxy. General proxy says, I don't care what's in front of the membership. I give a donee the right to vote for me in the way he wants to vote for me on any item in front of the membership.
Just remember you're talking about a condo.
Yes.
Okay.
Okay. And I will specify. What you see
I don't want to
most-
get me confused.
What you see most in a condo association is a limited proxy. You will almost never see a general proxy in a condo association, except only if they are trying to hit quorum. If they're not trying to take any other action you may see a general proxy that says, we're not doing anything. We just want to hit quorum so we can have this meeting and we can do the reports of officers and directors.
And to clarify on that, that means because in the condo association, we're going to very likely be voting for surplus. We're very likely going to have 2 votes. Well, depends now. We're probably going to have the surplus vote, and then every other year we'll have the financial reporting vote if they're choosing to try to reduce financial reporting requirements.
That's right.
So if you release a general proxy, you're not going to get the votes for either of those.
Yes.
And there are threshold requirements for both of those votes that you would probably want to get.
Exactly. So if you want to vote to lower your financial reporting requirements, if you want to vote to roll over surplus, you're going to need a limited proxy. And the limited proxy says, Adoni's going to be there for me in terms of establishing a quorum. But in terms of these 2 questions, the financial reporting question and the surplus question, this is the way I vote, yes or no. And Adoni's only action is to say, I am here instead of Kyla, and this is how she votes. So Adoni will not have the right to determine how to vote on behalf of my unit in a limited proxy. Condos require limited proxies over pretty much everything, except for establishing quorum.
Got it. So next question we have, back to the 1-hour continuing education. What happens if we don't take it?
Well, at this point, we don't have any classes to take, so I think we're good to go for now. But once those things get firmed up and we actually have parameters and now we have classes and providers to provide those classes, I would suspect that you would get suspended from the board as well. I don't know. Just hasn't happened yet.
Are we nonprofit? So I think this question is, what is the difference between nonprofit and not-for-profit? Which we actually have we had a discussion with Mark Gersel from Gersel, and he kind of had a discussion about that. I don't know if you want to.
What? I have no idea. No, I do have an idea, but I would love to hear what he said.
So I would have to find the video. Pretty much, there's two things you can be. You can either be nonprofit or not-for-profit. The difference between the two is basically, was it 501c3?
Yes.
Which is the type of foundation. Now, not to confuse some folks, because we do have some associations that have a foundation that's separate to it. Usually it has CARES in it or something will be in the name.
Okay.
We're using Apple Tree Condo. Apple Tree Condo CARES. It's a separate set of books. The money that goes in there does not benefit Apple Tree Condo in any way. It benefits things that are outside of it. Most of our associations operate as an entity which it's for their own benefit. So the money goes in and the money goes out. We're just not generating a profit.
That's correct.
In those cases, we still owe taxes. The fee that you pay to the association is not a deductible expense on your taxes, any of that. And kind of the difference between these two concepts. I think that there is sometimes a misconception. I've been in board meetings this year. I was in board meetings where they were trying to find a way to make their maintenance fees a tax deductible expense. They're not. They're trying to find ways to not pay sales tax. As far as becoming an exempt entity for sales tax, there's really very few ways you could go into that. One of them is, yes, you could be that 501c3 foundation type setup, or the other is you're reselling something. So, if I'm buying this microphone to sell it to you, the taxes will be collected when I sell it to you. It's not collected when I purchase it. So there's an exemption certificate there.
That generally doesn't happen for our associations.
Fair.
The 501c3 is a part of the tax code, and it's basically what charities have, what foundations have, where they are doing something out into the community. So that would be the nonprofit application. And then the not-for-profit, which is what most of our associations are, is exactly what you said. We are not generating a profit, but we are still a business. We are still taking money in. I get this question a lot when people volunteer their time and they'd like to get credit for it, or people volunteer to fund something in the association. So we need benches across our common areas. Can I pay this and get a certificate from the association? And unfortunately, the answer is no.
So this is not listed on this question, but this brings up an interesting concept that created a whole situation for us a few months ago. I had a director ask for a meeting with me, and the meeting was to see if they could get credit for volunteering on the board as part of their community service requirement.
Boy.
Which opened up a whole can of worms, because now you can't be on the question. Yeah, well, you can't be on the board. I'm like, hang on, what is this community service requirement for? And it was for
Really?
Yes.
Oh,
So
okay.
now we're not on the board anymore, right? And
Oh,
we
good,
have to have
good,
that
good.
discussion
Yes.
and remove them. But and they actually did decide to remove themselves from the board after we brought up the concern, and we didn't know about it. But that would be another example of, which I hadn't thought about this. Really, as a management company, should we be requiring background checks for people before they're allowed to go on a ballot?
I don't know if I would go that far. I've had to deal with this question over the years as well. I don't know if I would go so far as to require a background check, but what I have done is when they send in their notice of intent to run, there's usually, I would like to put like a little affidavit on the bottom of that notice of intent to run that says, certify that I am not a felon that hasn't had their civil rights restored for the last 5 years. All of the eligibility requirements, I put it in there and I make them sign it. So that at the very least, we have a document that says, hey, you said that you were eligible to run. Why is it now something different?
Yeah, and just to also clarify, it's only for felonies. It's not for misdemeanors, correct?
Correct.
So, in this case, this was not a good thing. So we won't go into it, but it rose. It wasn't like it wasn't a theft, at least, but it was not a good situation.
Yeah.
It wasn't something that was a moral questionable issue. But so, it's
Well, the
basically
kicker here is you must have had your civil rights restored for the last 5 years.
correct.
And so if the person is still going through community service.
Yeah, well, this was
probably-
basically a felony reckless charge. Yeah, it was out of another
Yeah.
state. He was
Yep.
exceeding the speed limit by an extraordinary. So that's where this had come from, and he got assigned community service in another state.
Yeah.
Just trying to find a way to meet that community service.
One of my favorite stories is when I was asked by a board to send a violation letter because somebody was receiving too much DoorDash. Close friends. No, and it's one of those situations where I really like practicing this type of law because most days I deal with real law stuff. I want to discuss contracts and negotiate them and talk about serious things that we need to get done for the association. And then other days it's, can you write a violation letter because this person is getting too much DoorDash? It's causing a disturbance to all of the other owners.
I'm curious how much DoorDash causes them to.
I have no idea. I think it was basically an owner-to-owner dispute. Somebody who was friends with a board member. That's usually what happens. And my first response is, where is it in the rules that limits the amount of DoorDash that somebody can get? Or more importantly, what constitutes a nuisance? Are these DoorDash drivers, throwing trash everywhere? Are they kicking down our common element association property? What's happening? And it was literally, this person gets too much DoorDash. And I politely declined to write the letter. And I said, I don't think that it would serve the association well if I write this letter. It's not going to benefit anyone.
I did once have one of my directors ask me to write, and they knew that it was going to be fake, but they wanted it to come saying that there was a limited amount of Amazon that could be delivered to a household so that he could give it to his significant other. It was a gated community, and people were leaving Amazon boxes like outside of the gate.
Yes.
Because they couldn't get access, and so he wanted me to have a fake letter that he would go just to her. I'm like, yeah, we're not going to do that.
That's because it could get around. If there was a guarantee that it was only in that household, maybe we could talk about it.
Oh.
Interestingly, I dealt with that issue. I talked with a coworker of mine about Amazon deliveries. Because what happens when there's one Amazon person that's driving around the community and they damage something? They strike the gate. Who pays for that?
Have you tried dealing with Amazon on that before? Because I have.
Nothing happens. And of course, if somebody that's a guest or an invitee of the association or of certain owners come in and they damage something, your documents will allow you to pursue the owner. But how are we going to figure out which owners got affected by which Amazon driver?
Yeah, it's kind of like, it's the same thing with when you have like pool companies that are servicing a lot of pools or landscape companies. It's problematic. I was impressed. Amazon reached out recently, and I should reopen this conversation. They were trying to find a way to install devices on gates to get in whenever they need to get in, and also for our high rises and all of that. And I approached them with the problem that I was having, which was at a gate in Lee County that had been struck by an Amazon driver, which ironically, also an interesting thing, the Amazon electric trucks don't have license plates. I didn't until we went back and reviewed the footage. We have timestamps of when they went in, and I'm sure that Amazon has GPS on these electric trucks, but there was no license plate on the truck, which also kind of caught me off guard. But a person reached out. It turned out they were from a third-party company that's installing these on behalf of Amazon, so they didn't have a contact for me. But I would think that at some point, sooner or later, Amazon, if they're recognizing the need to have these gated entry access through a third party that they're going to create a department to deal with association deliveries. And then maybe we can talk to them.
That would be great. That would be great because it affects a lot of our clients.
Yeah, but we have similar situations with FedEx, UPS, all of that, trying to find ways to work that. All right, so what is left? I know we said we weren't going to do this. Please highlight the key differences between condos and co-ops. So first, I'm going to give my impression of a co-op versus my impression of a condo. All right, so when I think of a condominium, I think of these hypothetical areas in space that folks own. So if you've got a 10-unit condo that's 5 floors high, I imagine that there's 2 units on each floor, hypothetical areas of boundaries of ownership that exist. When I think of a co-op, I think of a company that basically owns this like an apartment complex and is selling the ability to live there as long as you want.
Right.
And you're going to be paying a CAM fee on the building.
Basically, yes, that's exactly right. So a condominium, the way that you look at the condominium is that you own your space. You own the inside of the walls, basically, or the paint it. That's what you own. And you own your share of all of the common elements. So the grass, the landscaping, the walls themselves. In a 100-unit condominium, you own 1/100th of that. The difference with the co-op is exactly what you said as well. It is the association or the co-op that owns everything, and you don't own your unit. You own a share of that corporation, and you're assigned the use of that specific unit. It's easy to think of it as almost the same, but they're really very different. The ownership structure is very different. Let's say that there's a lien against the unit, or maybe a contractor liens the association and the units. It's very different legally because of the way that it has to be liened. And I think it's more the way we look at it legally versus how life is actually lived in these places, because lived life in a condo and a co-op is very similar. It's just when it comes to the legal stuff, when it comes to the corporate stuff, that's when it becomes very different.
What do you think are the biggest statutory differences between the condo and the co-op?
Insurance, for sure.
Yeah, well, yeah, particularly on the flood side.
Particularly on the flood side, there's not much insurance requirement statutorily in the co-op side. And as we know, with hurricanes and the flooding that have come from the hurricanes, I mean, at the very least, the condominium statute provided us with some guidance. Although not great, there was some. In the co-op statute, there was nothing. And so, we kind of had to muddle through it with the help of our insurance brokers and different. I'm really hoping not for a repeat.
I certainly agree with you on that.
Yeah.
I guess the struggle that we have is some of the most beautiful properties we manage are cooperatives down on the beach. And I absolutely adore them because I love that era. It reminds me of the older Naples era. They are generally a little bit smaller buildings because they were built before. And this might be an old wives' tale, but this is becoming like a theme, by the way. Every time we do this, I'm like, this old wives' tale, and I'm looking for the person to tell me if it's right or not. So I was told that oftentimes buildings were built like as an apartment complex, and they were able to be converted to a cooperative. And I don't know if the statute just made that easier than making it a condominium or something.
I don't.
And that's one of the reasons we see a lot of these 70s era buildings that are, because if we look at most of the buildings we manage that were built in the 70s, they happen to be cooperatives. The condominium statute would have existed then, though, wouldn't it?
Yes, it would have existed. My thought would be maybe most of the developers of that era were coming from the bigger cities where the co-ops were all the rage back then. And then just now the newer, well, not necessarily newer, but more in the 80s and the 90s, we started getting more condominium associations. So maybe the trend was towards the condo association. And admittedly, it's harder to explain to the owner what they own in a co-op.
Yeah, and then it actually gets even more complicated. We have some of our co-ops that are on land leases.
Yes.
Which is another common thing down on the beach.
Doesn't actually own the land on which the building is placed.
Right, and so
what happens if the lessor, the person that's leasing that land, decides no longer to lease that land to the co-op?
And if you talk, it's like 2 parts removed, because you don't own a unit, right? You own a stock certificate to a association that doesn't own the ground.
That's right. So it's not attractive for many people.
Correct. And so that's a bit of an issue on the sales side. I think cooperatives generally have lower sales values because of it. It's much harder to get a loan on a cooperative.
it's harder to explain it to people because, again, trend side, everyone is more familiar with condominiums now. And so when somebody says co-op, maybe their mind thinks it's a condo. And I find that we have to do a lot more education of the owners. They've already purchased. Unfortunately, it's done. You are now an owner, or you now own a stock certificate or a share. Let me now explain to you what you actually purchased.
But there's also some advantages to co-ops, in my opinion. I guess it depends on how you want to look at it. You mentioned insurance.
Yes.
So in a condo, right now, if you're a cooperative, depending on what your documents say, you've got some latitude in the acquisition of that insurance. If you're a condo, particularly 2 years ago, when you couldn't get insurance, you would be there. I had condos that were unable to insure to 100% value. There was just nobody would offer it. So you're in violation of your documents.
Yes.
Whereas with a cooperative, depending on what's in your documents, you could theoretically insure to a percentage of the total value of the building. And that has allowed them to have some cost savings, depending on how that's played. Now, on the other side of it, we're talking about like in flood insurance. Flood insurance is going to be more expensive because they're going to have to go to the excess market, or they're going to have to do something because they're going to have a de minimis amount of insurance available to them. So there are advantages to cooperatives as well, but the statute is a bit murky. All right, last thing, and then we'll call it a day.
Okay.
Why is it necessary to file a lien on a past due owner after collections has been initiated? An estoppel is required before they could sell the property, which would show all past due amounts. A lien seems redundant, unless it's simply a step on the road to foreclosure. And this is actually kind of an interesting question.
Because I get this a lot, because I always recommend we file a lien in any situation where there's a delinquency, and this is why. An estoppel is requested before you sell the property if you have a title company involved.
Yes.
If I sell it to you and it's an owner-to-owner transaction, there is no title search, or there's not a requirement for a title search. And so it's happened to me where we're sending collection letters to a certain person, and the next time I go to send another collection letter, there is now a new owner to this property.
Yeah, that's a good point. So estoppels, just so everybody knows what an estoppel is, again, this might be an old wives' tale, and we could probably Google this if anybody has a phone. I'm told that it comes from a word that refers to the gate on a castle, the metal,
You are maybe right. I have no idea.
This is
We
what I
should
would...
have a session of just like
Old wives' tales?
Old wives' tales.
Of associations?
Legal words, you know.
So I was told that it had to do with that metal gridded gate that you see on castles that would allow you to see who's on the other side of the gate and decide if you wanted to open the gate to let them in. That could be a lie, but I bought it at the time. I was a young Cam at my class.
No need to verify. It's the truth.
Someone chat GPT that for us. So the estoppel doesn't stop somebody from purchasing property. It just tells them what those requirements might be. And the estoppel is generally prepared. We use HomeWise docs for ours just because I think that this is another area that management companies we have like 1 foot in the camp, 1 foot out of the camp on the estoppels because estoppels, there is huge amount of risk whenever we do these. Right now, it's an incredible amount of risk, particularly on the condos, because you've got the CERS, the milestones. The condo questionnaires on loans have become extraordinarily difficult. I think that it was something that at one point management companies didn't mind doing. Now, if I could get out of it and not have to do them, I probably would find a way to step out of it. It's a loss. There's a charge for it, but we lose money every time we do one.
The charge is dictated by statute. And so it's not like you can charge what you feel the value could be. It's just what the statute and what the DBPR says you can charge for.
The statute actually allows us to charge more than we do. The mental reminder to Adoni, we need to adjust that.
Yeah,
I think
you need to up that a little bit.
We do. It's apparently we're using the numbers from about 4 or 5 years ago, the max, so we can up that. But even when we up it, I still think it's going to be a loss. It's never been something we've wanted to do and make money on. And then the condo questionnaire is its own thing. And then not to get too far off track, but there's not always, but there has been a bit of a push to try to make the estoppel cost part of closing concessions. It's important to remember, so we do an estoppel and we try to create all of this data to help somebody know if they want to buy the property or not. Well, if they don't buy the property, who's responsible for those costs, right? And so that's becoming, and so now we would have to track it. I forgot where I was going with this, but so the estoppel tells you what you would owe or what you wouldn't. If a person does not use a title company, which wouldn't be wise, even if it's a person-to-person transaction.
It wouldn't be wise because you have no idea if there are any liens on the property, if there's an encumbrance on, any other, maybe there's an easement on the property that you have no idea about.
You don't even really know who owns the property. We had a situation another Gulf Shore Boulevard association where an acquisition happened. And I remember we ended up getting the phone call because they're like, why hasn't this person gotten a new owner's packet? They just bought this. I'm like, we didn't even know they bought it. And it turned out that they had paid a person to buy a piece of property that person didn't own.
Boy.
It was something that was in a trust.
Yeah.
And this was like the brother of the person
Right.
who had
So
the
they
trust.
had no authority.
They had no authority to sell
The
it.
sale never actually happened.
Correct, but the money moved.
The money's gone.
And so now, and we ended up getting intertwined with it. So having a title company, you should always run title search on any piece of property to find out if you could, actually can purchase it.
Well, going back to this question, it's important to put a lien on the property because at the very least, if an estoppel is not looked at or an estoppel is not requested, the lien serves as notice to the entire world that says that the association is owed money. Recorded in the public records now. It's not. There's no system that tells the whole state of Florida. It's just in the public records of the county where the unit is located. It basically says to the world, there is a lien on this property. If you're not looking at the public records, I can't help you.
You're going to buy a car that's $15,000. I use Carfax, right?
Exactly. But at the very least, we want a lien recorded so it tells the world that there is money owed to the association. That's really the point of the lien.
Do you remember, I don't know if you know about this or not, it's one of our mutual clients that had a transaction from a card game.
No.
Yes, we have a it was a poker game at the clubhouse, and the
Yeah.
guy wagered his house and lost his house at the card game.
There you go.
And
Title search.
there was no title. Well, I was just thinking, I was like, that was a no title search, and then we were made aware of the transaction. I'm like, oh, is this like an April Fool's joke?
That's amazing.
I'm like, how does this work?
It was probably
And-
one of his or her 15 different houses. So
Yeah, I don't know. I mean, but yeah, I remember a transaction, no title search, because it was lost in a card game.
wow.
So what do you think is the most common question? And then I'll let this go. I know I said that was the last one. What's the most common question you get from board members?
How do I keep myself out of trouble?
How do you get, and so what is the answer?
Follow the advice of your manager. When you have an issue that's legal, go to your attorney. When you have an issue that needs an engineer, go to a Florida licensed and insured engineer. Use the professionals that are available to you to obtain advice before you make a decision. Don't use the neighbor who used to be a lawyer, who never practiced condominium law outside of Florida. That is how you're going to get in trouble because you are not using the resources that you may have before you make a decision on an item that you are not familiar with. That's how you keep yourself out of trouble and make decisions for the entire community and not just for yourself.
Yeah, I think that's all probably a very good answer to that question. I think that, and I'm not marketing for her, but I think having a legal budget is useful. If you're running an association, there's going to be legal questions. There's a difference between a management question, which would be, hey, can you got a roofer that can fix this or something like that? Those are usually where your property management questions go versus another, well, I guess they're technically a past mutual client of ours, which was, can I replace this roof with a totally different roof? That's something where we're going to need to get an attorney involved. And when decisions like that are made, your management company is going to say, I can't give you a legal opinion. This is a material alteration or not. I can't tell you that. You need to talk to the lawyer. And then if you choose to talk to the lawyer, she's going to give you an opinion, which is just an opinion.
That's right.
The board then can choose to follow it. But at least if they follow that opinion and it goes sideways, they can blame you.
Exactly. You can point to me.
Kyla told us we could do it. So yeah, I think that's probably, how do we stay out of trouble? I hadn't thought about it, but that's probably, and I'm surprised that from our director questions, that was not one of the ones that we got. Although I guess actually they all are. All of these are basically asking that question just in more specific.
Yeah. These boards, these directors are getting paid $0 to be part of this. And there is a lot of liability for them. And most of the people I meet are very kind-hearted and they want to do well for their community. And we want to help them do that. That's what you're here for. That's what I'm here for. It's just, we want to make sure that they are making the decisions that will help the entire community.
And that's so hard to do because I used to have a boss, great guy. He used to say, the road to hell is paved in good intentions.
That's right.
That's the way because we would always, it was a higher risk industry. But when we ended up messing things up horribly, it was all based on good intentions. The condominium concept or the HOA concept is that people are volunteering their time, their talent, all of this to help. The question becomes that gray line of when did we cross it? So we're going to redo the community room, all right? We've got a bunch of volunteers. They're going to be painting. They're going to change the flooring. They're going to change the electrical outlets. We got some plumbing issues with the toilet. We're going to put in a new toilet. Where did we cross the line? Did we cross the line? And then the question becomes, and I'm just giving this as a hypothetical. So you've got this group, they volunteered all of this. They saved the association $20,000 or so by doing it all themselves. But did we need a permit to replace that toilet?
That's right.
And did we cross a line there?
And the electrical, did it require a permit? What if the person was a very great hobby electrician, but not somebody who was licensed to do this, and something went wrong and caused the fire? Now who's liable? What if one of our volunteers gets hurt? Do we have workers' comp insurance? Are they under the workers' station umbrella? Have we checked with our insurance broker? So you're right. All the road to hell is paved with it.
Yeah, and that's the idea. The concept is that to live in a condominium will cost you less than living in an apartment complex, because you're not paying for these people that are going to be making these decisions. Your board is not there now. And then oftentimes you have board members that they try to pick up stuff from management to try to reduce management costs, because management cost is you've got the accounting cost in there, but it's really just a function of the time the manager needs to spend. Managers are about $100 an hour or so. So if you've got a director who's out there, I'm going to do this project instead of having a project manager involved or whatever, they're volunteering their time for it. That's saving the association money. But at the same time, is it opening up a concern? Or, Christmas lights, another one. Sometimes they love putting up Christmas lights, but are we creating
what happens when somebody falls?
I had a situation last year during Christmas where a group of volunteers installed these Christmas lights, and what ended up happening, we didn't know it at the time, we started having problems with the elevator. And it was in December, and we're like, maybe it's because people are back, and we just have work done. And it turned out that what was happening was these Christmas lights were tripping a GFCI fault, which was tripping power to the elevator, to the elevator's communication system, which had a backup battery, which would then beep. So now we've got this beeping. We're trying to figure out, why is this on backup battery? And we kept trying to reset it, and we're troubleshooting it. And it turned out it was related to Christmas lights. Sometimes we have stuff like that. All right. Well, Kyla, we appreciate your time. We'll have you back to discuss co-ops in more detail and whatever else ends up coming to folks' mind.
Sounds good. Thank you very much for having me.
Thank you.